together with a copy of certified the attention of the complainant an original degree it was cancelled that despite having received the complainant managed to bring the original copy certified by the institution was sent directly to the at 4:48 p.m. made reference supplementary affidavit by which the complainant eventually counsel stated that on the two documents at 4:40 the complainant for failure to his submissions by stating that 17 IEBC certificate certified by certificate must be certified roadblocks for his clearance to vie in the 9th that there is no requirement by the university that issued the complainant was well degree certified defeat his demand that all for one to present. He therefore argued that since the degree certificate should be clear despite certificate being 75 of the Constitution, 6 of the Constitution. This argument that the two to bring this into perspective, 193(2)(g). With this in mind, counsel submitted brought to the attention of the respondent insisted that to prove that he indeed against his removal from by the Senate. Letter written by the was an active appeal to the respondent by the Deputy Registrar were presented to the respondent letter from his the Supreme Court of Kenya before the Supreme Court Constitution to take a step whether those documents, the respondent, the issues. Of the Constitution, the rest the sovereignty of the 82 of the Constitution to vie for a gubernatorial seat. Proceedings can be challenged to the High Court or 93.3 of the Constitution. He contended that the constitutional imperatives, the complaint 59.1 of they argued that the respondent, he further argued that only that the respondent demanded which were brought while the complainant. According to counsel, there is this committee the rights under Article 30 this year. That article, who is required to ensure of equality. On the issue of double reference to a Gazette notice, name of Governor senatorial candidate in he had been impeached. The complainant, he pointed out that and Waititu had a case before the matter before the Supreme Court. And Article 3 and 21, he argued that petition is not up to submissions by clarifying that Ferdinand Waititu argued that the documents 2021 and no that notice referred to, but an intent are clear. Counsel as an aspirant on the political rights, counsel and the laws that govern the issue was brought to in the complainant's of evidence from the bar. That there was no request extension of time to failure to comply with the petition and failure from the relevant. Only challenges that the Supreme Court had lapsed out of time document 2022. Regarding the claims of the existence of Supreme presented to the respondent, counsel for the respondent that PM. Additionally, Complainant's counsel only on time in contravention. Counsel also played by the complainant's counsel. Any of the documents that the counsel maintained and 3 because prosecuting and self to distinguish between admitted that eligibility is very wide in scope. To look at Article 110 and 181(1) the grounds of impeachment. 1090 published on 18th December impeachment of the complainant 2G, but which falls Article 181 held the position that there on documentation replying affidavit. Documents must be presented. He argued on 3 grounds that a copy of the degree certificate of the university 20. He was disqualified. Counsel submitted that in the electoral process in the law. Counsel for the complainant 2 p.m. Yeah. Before the respondent opportunity to present his papers, the first claimed that the complainant was date of 7th June 20. Requirement, but was decided by the Senate, and that the 32G has been. He also submitted that article cannot be read in isolation of the Constitution. For one to be elected, be eligible the Constitution. For disqualification, its obligations under Articles 259. He explained, protect and advance the provision. The committee's decision is and considered the pleading. The committee makes to consider in rejecting the complainant's on in mind that the following grounds: 1. Original provides that to be the educational qualification with section 22 above of the certificate to the respondent. That was being accepted by IEBC for by the university issuing authenticate a document and by certification by an advocate in the present elections. Agree was applied to the board, whose part or 2017 certified copy of a document. The law provides that public properly certified which provides that one aspect shall give that on payment of the together with the certificate, true copy of such document, and such certificate officer with his name and shall be sealed. Make use of seal. So certified. It may be true certificate certified by his requirement that for purposes issuing institution, the requirement that a degree certificate other than the complainant aspirant of equal found a claim for complainant has admitted that he was presented to the same position of the rest mention that she did this certified copy. We understand the clearance as he himself sent her before 4 p.m.
Cross that out. Because 57.
Oh, yes. In DRC, served as follows. The reporters within the prescribed time could have been avoided for the nomination process. The complainant had presented his document to, and there was a problem. The complainant had appeared before to the complainant presented his degree by the university. Regulation 2 in the afternoon for respective elections. Number 434, 2022, in which at paragraph K in Edward Mukaya independent electoral and boundaries where of this committee the code and the fact that a returning to decline to clear an of the time specified. We have in the judgment, and that can be the Supreme Court delivered on 26 March that she is entitled imposed on any party or inadvertences we therefore find Section 22 of Elections Act stands with the same. Lennon, that the respondent needs to adopt our reasoning in number 239 of Graham, Samboja, and others for it for consideration. During the hearing, admitted all this ground affirmed in Gazette Notice number 4 of 18th December so the Supreme Court of Kenya Supra that is part of the Commission's mandate introduced before it during nomination to the qualification of. However, this letter 22 by 4 p.m. With the document, there is Article 47 of the Constitution. Documents were authentic. Graham Samboja was in question to conduct investigations on documents. The second respondent petition under Article 88 of which includes the connections to established by the Constitution. It appears does not include certificates. It therefore to investigate and or otherwise candidates as long as the valid document on 7th June 2022. By the committee, interaction between Article 75 went on to state in conclusion that does not extend inquiries into of an aspirant must be on a body. Investigate the proving the existence of on for clearance addiction. However, conclusions made by the court are at the very least persuasive on this committee. The issue of Article 7 of having treated to justify the decision, that Governor Ferdinand White, as the governor, according to opposed by who stated that the said Ferdinand word of the High Court in Boundaries Commission either must satisfy is grounded enacted to give effect. Such regulations aim at compliance with any of the it is making nomination to permit and statutory requirements in the process to avoid the court notes that I am on valid grounds and also the applicants incumbent upon persons seeking constitutional and statutory requirements to adhere to the set guidelines, time frames, and the authorities cited above. The complainant has not of the mandatory requirements
to this particular complaint as follows, and is hereby dismissed. As to costs.
Much of that for officials and maybe that fixed mind handle this at you and extend it to the committee. And for that matter, we be given a copy of grounds for appeal.
Okay.
Actually placed in your hands. Chances. Tomorrow we'll find ourselves. So these are matters that actually before the long time ago, I saw it at 5 in the morning.
Okay, Mr. Nyamu, to make. So let's say, is it possible for you to start doing it now? The draft? How long will it take? Okay. And then Salome, you can be. But in the meantime, you start. Okay? All right.
praying for the audio so that we can check.
Is them. We've contacted a professional audio. Just a moment. You want raw audio? Following one, while the commissioners consider that. It is the we are. Why don't we listen to the next matter? Be the same. Yes. Isn't that the reason why the High Court? We do not have to call the High. I respect when you have a lawyer of your son. Thank you, Dr. Kamino. It's not something we expected from you at all. They play a facilitative role in this committee. Please, let's have the next matter. Yes. Number 177 of 2022. And Maureen, what commission to say? No, we'll do that after this, Dr. Kamino. Okay. Okay, Dr. Kamino. I'm sorry. I'm sorry.
I'm suggesting that instead of reading the one for Wiper, instead of reading it only, and we've agreed.